Good afternoon. For the past 3.5 years, each week this program has opened with me and David Lair welcoming you. As our America at a Crossroads community has already learned, yesterday morning, David Lair suddenly and shockingly died. Like so many of you, I still cannot believe it. Despite our grief, we made the decision to proceed with tonight's program because David's wife, his children, and his family, and our America at a Crossroads leadership agreed that the greatest way to honor David is to dedicate this program to his memory. And so that is exactly what we will do tonight. David Lair was a magnificent, uniquely loving, brilliant, and talented man. A lawyer by training, a passionate believer in and defender of our democracy, our Constitution, and our civil rights, and an advocate for truth and justice. I met David in the mid-1970s when we were both young professionals in the Jewish community. David left his job at a big, prestigious law firm where he had a very bright future to pursue his passion of working in the public interest, fighting bias, racism, and hate as general counsel of the Anti-Defamation League. He eventually became the Western States Regional Director of the ADL, a position he held for almost 3 decades. He subsequently created Community Advocates, a nonprofit organization that advocates for innovative approaches to human relations and race relations. David was on the founding committee of Jews United for Democracy and Justice. We created the most amazing partnership as we developed this weekly virtual town hall program. As you gathered from hearing from David every week, he was passionate about our mission and very proud of this America at a Crossroads program and of the community of curious, intelligent, and engaged people which comprises our weekly audience. In response to our announcement this morning about his death, I have received literally hundreds and hundreds, maybe more than 1,000 emails from members of our America at a Crossroads community. Many of you expressed the feeling that even though you never met David in the flesh, from our weekly programs, you feel like you have lost a beloved friend. Those emails moved me, Mel, and Zev, and we will be sharing them all with David's family. David was a magnificent tapestry of the most positive human characteristics. He was soft yet tough, bold yet humble, always ready to speak truth to power, to call out injustice and false information, and he was wise beyond measure. David was fully aware of the enormous threats to our Constitution and our democracy, but nevertheless, he was always able to find optimism and hope. He was wholly realistic about the dangers, but unwilling to yield to hand-wringing and hopelessness. In fact, in pre-program conversations with our moderators and speakers before every one of our programs, David asked our moderators and guests to try to end each program with at least a drop of hope and optimism because he couldn't bear leaving you, our audience, depressed and hopeless. David was my true partner, my editor. We spoke every day, sometimes many times each day. In the 2 days before he died, we traded more than 100 emails, all in service of America at a Crossroads, all in service of bringing the smartest people to speak to our audience on the most important, cogent topics of the day, and all in service of working to preserve and protect our democracy and restore our societal decency and norms. I mourn David and I celebrate David. It was one of the greatest honors of my life to have partnered with him on this project. As one of the notes today suggested, and I think it expresses the sentiment of so many, we all feel like we lost a limb when we lost David. In his name, we will figure out how to carry on without his brilliance, his energy, his beautiful smile, and his fetching enthusiasm. He will always be present in our hearts. For our LA audience, David's funeral will be at Mount Sinai, Hollywood Hills at 10 a.m. on Sunday. I now welcome David's and my America at a Crossroads partners, Zev Yaroslavsky and Mel Levine, as well as Rabbi Ken Chasen of Leobeck Temple, for a few additional words about David. Following their words, we will welcome our esteemed moderator, Larry Mantle of LAist, to continue with tonight's program.
Thank you, Janice. I've known David Lair for nearly 50 years. He was a colleague and a partner and a very dear friend. He was a fearless advocate for our democracy, our Bill of Rights, civil liberties, and the separation of church and state. As a warrior in the fight against hate of all stripes, he fought fearlessly. He was dedicated to preserving and protecting our democracy as he saw its growing erosion. David was a consequential crusader for the founding principles of our republic. And when confronting the profound challenges of his era, he did it with intellect, not with rancor. He was the personification of a mensch. We have lost a giant. David was taken from us far too soon. He had so much more to give. His untimely passing recalls the words of the Israeli poet Chaim Nachman Bialik. There was a man, and look, he is no more. The music of his life suddenly stopped. There was another song in him. Now it is lost forever. We will miss you, David, very much so.
I'm honored to join my colleagues Janice and Zev in this very difficult moment. I also have known David for about 50 years. David and I actually worked together on a project a little less than 50 years ago. We were both involved in particular parts of the Jewish community, and we had come up with, along with others, an idea that we thought might stop the Arab boycott of Israel. And David and I worked hand in glove on this project. It actually ultimately had a big impact on stopping the Arab boycott of Israel after a struggle for many years. But in working with David on this project, I got to know him very, very well before he turned 30 years old. I wasn't much more than 30 years old myself. And I found David at that time to be filled with really good ideas, unbounded energy, a total determination to accomplish our objectives, and a combination of just all of the best things that you would want in a human being. When we collectively started Jews United for Democracy and Justice, the idea was to be a Los Angeles voice for civil rights and civil liberties to counter the frightening anti-democratic things that were going on as soon as Trump was elected. And after COVID hit, after we were having speakers live a few times where we'd get a few hundred people each, David came up with the idea of doing these Zoom calls. David told the rest of us, look, during Zoom, people are going to have to stay home anyway, and we might be able to attract a broader audience than we were able to do live, and our speakers might be not nearly as expensive as they historically were. And that started something like 3.5 years ago and led to this extraordinary series of normally Wednesday evening talks, where we have wonderful people to give us some guidance and assistance, such as the person we have here tonight, Neal Katyal. So I join with Janice and Zev in mourning David and in being eternally grateful that he was our friend, our partner, and the stimulus for something and so many things that were so critically important in the fight to preserve American democracy. We're very, very fortunate that my rabbi, Ken Chasen, has agreed to spend a moment or two with us in memory of David as well. And I yield the floor to Rabbi Chasen.
Thank you so much, Mel. In loving memory of David and in deep gratitude for the bright light of his legacy, I'm honored to share these words of poetry written by Maya Angelou. When great trees fall, rocks on distant hills shudder, lions hunker down in tall grasses, and even elephants lumber after safety. When great trees fall in forests, small things recoil into silence, their senses eroded beyond fear. When a great soul dies, the air around us becomes light, rare, sterile. We breathe briefly, our eyes briefly see with a hurtful clarity. The great soul dies, and our reality, bound to him, takes leave of us. Our minds, formed and informed by his radiance, fall away. A great soul dies, and after a period, peace blooms, slowly and always irregularly. Spaces fill with a kind of soothing, electric vibration. Our senses, restored, never to be the same, whisper to us, he existed. He existed. We can be and be better, for he existed.
Thank you. Larry.
Thank you, Rabbi Chasen, Mel, Zev, and Janice. I have to be honest, this is going to be one of the more difficult programs that I've done in a career of nearly 40 years of interviewing people, because of how highly that I thought of David, how important he was to me professionally and as a friend as well. I just want to briefly mention about our working relationship. I met David more than 30 years ago when he was with ADL. And after the founding of Community Advocates Inc., David and I collaborated on many in-person events for my daily program, Air Talk, on LAist. We did them throughout Southern California. David had terrific ideas for our programs. He found the strongest speakers possible. This sounds familiar for those of you who regularly watch America at a Crossroads. It's the same formula. It's David's insight into who would be great guests and what are the issues that we need to be talking about now. One of my favorites of those programs was a mock negotiation for peace in the Middle East. Now, David lined up the then Consul General from Israel, who was based in Los Angeles, as well as a leading advocate for Palestinian rights. Those were our two guests, a live hour during which I led negotiations between the two. Now, we reached agreement on a two-state solution with borders that they both accepted, transportation corridors between Gaza and the West Bank, and compensation for Palestinians for not exercising a right to return to land that's now Israel. And on our final issue, control of Jerusalem, we couldn't reach an agreement. I worked hard on a compromise, but hit a wall as our broadcast time ended. Nevertheless, it's one of my proudest professional moments. The entire concept was David's idea. How audacious. And he and I reminisce about it up until just a few days ago when we were talking about that program. I miss him. I appreciate him. He's such an important person for me professionally. And at the end of our program tonight, I'll share a few more thoughts. But let's begin the program this evening with our guest, and it's a pleasure to introduce attorney and Professor Neal Katyal, partner with the firm Hogan Lovells, and the Paul and Patricia Saunders Professor of National Security Law at Georgetown University Law Center. During the Obama administration, he served as acting Solicitor General of the United States. He's argued many prominent cases before the US Supreme Court on matters like the constitutionality of the Voting Rights Act and the Affordable Care Act. His honors are numerous, including one I understand he's receiving this evening. So yet another honor for his distinguished career. Professor Katyal, thank you very much for joining us this evening. Good to have you with us.
Thank you so much. It's a delight to be here. I'm sorry that we're here under these circumstances. I got to know David a bit through these programs, and he was so intelligent and wise and decent. And the last weeks have been so trying for all of us, but I know especially for many of you watching this video. And I just, my heart goes out to everyone, and particularly to David's family.
And David was so intent that you be a part of this series. He said he was working with your team to try and get a date to do it. And he was so happy when you agreed to do the program. So thank you for joining us. Let's start with the many legal challenges that former President Trump is facing. He's been fined again for violating a gag order in the New York civil trial prosecution that's going on right now. That's the one that alleges that his company was vastly inflated in value so that it could secure loans. Of likely greater consequence, we have 4 of his co-defendants now, with the most recent this week in the Georgia Fulton County racketeering prosecution, pleading guilty, almost certainly cooperating with prosecutors in that racketeering case. First of all, let's talk about Georgia. How significant are these pleas? 3 of his former attorneys, total of 4 people pleading guilty. What does that bode for him?
Okay, so first, just because not everyone is keeping score at home, so I just want to outline all the different legal challenges that Trump currently faces. 4 of them are criminal, 1 of them is civil. So in New York civil, and that's what you had said initially, Larry, this is a claim that Trump was inflating and deflating the values of his assets, like his New York apartment, the place he lived. He claimed it was 30,000 square feet. It was 10,000 square feet, things like that. And told one story when he was trying to get mortgages and claimed he had more assets and equity than he had. And when he was trying to pay taxes, claimed they were worthless. So that's the basis of that lawsuit. There's also a separate New York lawsuit, which says that he paid Stormy Daniels money for her silence, and that money was a campaign contribution. That's the first of the criminal indictments in terms of sequentially. That was the first indictment. And then you have in Georgia a criminal indictment for January 6th against Donald Trump and 18 other people that he's associated with. And you have a criminal indictment in Florida, in Mar-a-Lago, at the federal level for stealing classified documents. And you have a federal indictment in Washington by Jack Smith, the special counsel, for January 6th, only against Donald Trump. The other one is against 19 people, the state one. This one's only against Trump. There are several people named as unindicted co-conspirators. All of them could and probably will be indicted down the road. Okay, so the question here that Larry's asking is, what is the significance of these rapid fire pleas? They've all happened in the last week. We're meeting a week ago. We couldn't talk about any of them, but you've got some of Trump's closest lawyers, like Jenna Ellis, saying, yeah, I did it. I committed a state crime, a state felony for her. Sidney Powell, Ken Chesbrough, all doing that. When Sidney Powell did so, Trump tried to claim, well, I don't know who she is. Not my lawyer. Problem was, he tweeted she was his lawyer. She also said she was his lawyer. Very hard. And Ken Chesbrough probably had less direct contact with Trump. Sidney Powell, we know, was at the Oval Office on December 18th during the meeting where evidently Trump thought about making her special counsel to investigate this. And talked about seizing the voting machines and things like that. So it's very hard, I think, for Trump to really have too much distance between these people. Why is their testimony so significant? Well, for Powell, and I believe also for Chesbrough, they have already recorded as part of their plea deal the testimony that they want to give prosecutors. It's a videotape. And that was part of the plea deal going in. And the plea deal also says that they're not allowed to talk about it with anyone. You, me, the media, other defendants, nothing. So it's a black box. My guess is that black box has some pretty significant testimony in it, because I don't think prosecutors strike this deal unless they think that there's really helpful testimony. Will all that testimony be against Donald Trump? Maybe, maybe not. Some of it will go to Trump's state of mind, what we in the criminal law call mens rea. So in order to commit a crime in our American system, you need to have a bad intent, a bad mens rea, and you need to have a bad actus reus, a bad criminal act. And Trump's defense so far has been, well, I didn't have a bad mens rea. My lawyers were telling me this was all okay. So to hear from the lawyers and to have the lawyers say, actually, that's not what we said, or he didn't really believe this, and this was all a legal fig leaf in order for him to try and sow discord about the election and create uncertainty. All of that could be very gutting to his defense, and I suspect it will be.
Neal, how much will testimony that we heard during the second impeachment trial, I believe it was, of the president, in which it was testified to that he admitted he'd lost the election, but was saying that it had been stolen from him. And because I would assume part of his defense is going to be, look, this is what other people who feel they were wronged in elections. We've had Democrats who've protested what happened to them and try and challenge it wherever they could. So how important is that claim that he admitted he lost?
It's quite important. So Cassidy Hutchinson testified to that. She can, of course, be cross-examined about that and attacked or whatever on the stand. But that is, I think, pretty helpful testimony in showing that he thought he lost and yet did this other stuff. Now, it's not a defense, Larry, to say, well, Democrats might have thought they won, Al Gore, something like that, because the question is, what did you do after you thought that? And it's one thing if you do what Gore did, which is bring some lawsuits, and when you lose the lawsuits, throw in the towel. It's another thing to do what Trump did, which is literally try and go to state legislatures and have them appoint fake slates of electors to replace the ones that the people had voted for. So in our criminal system, as I said, you need a bad mens rea, a bad state of mind, and a bad act. And for like that example, the Gore example, even if you think he had a bad state of mind, even if you think he was delusional or whatever, there's no bad act he committed in the course of the process. Whereas here, there obviously undoubtedly is. And notably, one of the four, to return, Larry, to your question, one of the four people who pled is, I think, one of these fake electors who had some role in that.
That's the bail bondsman who, yeah. Well, so where's the overlap between Jack Smith's federal case and the Georgia case when it comes to efforts to undo the election? Because Trump isn't being charged with the attack on the Capitol, but with trying to undo the results of the election and trying to interfere with the certification of the election. So what the fact that there is overlap, is that significant?
Yeah, so I would say the overlap is very, very strong. It's not some minor overlap between two fairly unrelated prosecutions. I think the gravamen of both prosecutions is Trump tried to steal the election and subvert our democracy, whether at the state level or the federal. They're crimes against both. And so we know the Supreme Court has said you're allowed under what we call the dual sovereignty doctrine to try both. So like if you think about Rodney King, tried in state court, the prosecution didn't work. So then the feds tried him, and the defendants, those police officers in that case, tried to bring their case to the US Supreme Court saying you can't prosecute us twice for the same crime. And the Supreme Court threw that out, saying if it's a different sovereign bringing the prosecution, yes, you can. And here there's a different sovereign.
In the case of the Georgia prosecution, Fulton County District Attorney Fannie Willis charged this as racketeering, essentially saying that all these individuals conspired in their effort. And this is not something we think of as applied to political corruption. Is this highly novel or extremely novel? And is that a positive or a negative for her to prove her case?
Well, you come from California, so I don't know what it's like there, but I grew up in Illinois, and RICO and conspiracy and politics pretty much go hand in hand, Larry, in Illinois. I don't know that we've had a governor who hasn't been indicted for one of those things before. Conspiracy is a very old doctrine. I wrote the kind of, I think what is most people say is the leading academic article on it in the Yale Law Journal back in 2003 called Conspiracy Theory. It basically goes all the way back to 13th century England. And the whole idea behind conspiracy law is that it's worse for society when two or more people agree to commit a crime rather than one person on their own. So there's this kind of dilemma, like, if I go and rob a bank by myself, I get a certain punishment. We'll just call it 15 years. if Larry and I rob the bank, same amount of money we take from the bank and we get caught, we each get 15 years. That's 30 years of social punishment society is putting out. Why should it be double the punishment for the same crime? And the answer is that it's much more dangerous when people act in groups, both because of kind of Henry T. Ford assembly line ideas, like Larry and I can specialize, and he can be the getaway car and I can be the person who breaks in. But also because psychologically we find that when there are bad groups that are formed, they egg each other on to commit even more bad stuff.
So how
Okay.
does the RICO, oh, I'm sorry, I didn't mean to interrupt, but I was just curious how the RICO Act then turbocharges that.
Yeah, so RICO is a specialized version of this conspiracy doctrine, a statutory version of it. And what it does is it basically says you can throw the book at someone who's a conspirator, and you can hold them liable, not just for the acts they committed, but also for the acts of everyone else in the conspiracy. And the reason why this is important is because it gives prosecutors a tool to say, Ken Chesbrough, Sidney Powell, Jen Ellis, okay, we know you weren't the one who organized all of the fake electors plot or organized the attack on the Capitol, but your co-conspirators did, and you are going to be liable for their crimes if they're foreseeable consequences of the conspiracy. And what that does in turn is it supercharges the practice that we colloquially call flipping. The idea that a prosecutor will say, you're facing very serious charges unless you come and give state's evidence and work with us and cooperate against the other defendants. So the entire point of the conspiracy doctrine, or RICO, is to supercharge flipping. And that makes an important, that's really important when you think about something like the Georgia prosecution and all these people who are being indicted, because it gives the prosecutor a big weapon to use to get people to finally tell the truth. And you think about it, we had all those January 6th hearings. Sidney Powell adhered to her cockamamie story. Ken Chesbrough adhered to his cockamamie story. Jenna Ellis generally adhered to it, though when she faced some disciplinary action in Colorado, she sang a bit of a different tune. But nonetheless, this is the magic of the conspiracy doctrine working in action. We're seeing it play out.
Now let's talk about the timing of these cases. At least 2 of these prosecutions take place in spring of next year, unless they're delayed, right? So right in the heart of the campaign, what are the prospects as we get closer to it that Trump's representatives will be able to push the date post-election?
I mean, this is really Trump's entire legal strategy. Everything you ever hear him say or do, you have to view under the lens of his attorneys are given one set of instructions and one set only, which is delay this trial at all costs until after the election, hoping that he can get pardoned or something like that. So, like, for example, just to start with Mar-a-Lago, this stolen documents case, this is easy case. This is something like, I've taught criminal law at Georgetown for 20 years. I'd be and there's more 120 students at least in my class every year. I'd be very comfortable with literally any one of those students while in law school prosecuting this case. It's that easy. It's not hard. The guy did it. He's admitted to it. His defense is totally bogus. I, the president, can do whatever I want. This requires no brain power to win this prosecution.
There's no need for the prosecutor to prove a motive for him to do it?
Nope.
Okay.
Nope, motive's not part of it. And you can understand why, because sometimes motive is very hard in these classified material investigations, whether you can trace it to a foreign intelligence service or, greed or corruption becomes very hard. So no, it's a crime every day of the week to do what he did, regardless of motive. So
Neal, so let's talk about if the judges hold firm and these cases go to trial, and let's say the president gets convicted and is given actual time of incarceration. Is he able to serve if it's a federal or a state case? What's the law say about that?
Yeah, so there's, I mean, two different things going on. One is just, will he be in prison before or during or after an election? And even if the trial schedules hold in Mar-a-Lago, which is right now, I think, an end of March trial, or the January 6th trial, which I think is the beginning of March, nonetheless, you know, and if he's convicted, as I think he will be in both of those federal cases, he's going to file a motion for something called bail pending appeal, which means you can't jail me while I have an appeal going on. And, you know, he's likely to get that because, you know, there'll be arguments on the other side, but at least I could imagine a court saying we're not going to jail the former president until it's signed off on by an appeals court. So what that means is he's going to be free until the election and while his appeal is pending. And if he wins, his plan will be to dismiss those appeals. He'll tell the Solicitor General at the Justice Department, that's the role I used to have. Normally, the president leaves the Solicitor General totally independent, but Donald Trump doesn't leave anyone independent. I'm sure he will order the Solicitor General on day one to drop the prosecution. And that will be the end of Mar-a-Lago and the end of the federal January 6th prosecution. It will not be the end of the state prosecutions, either in New York or Georgia, because in our federal system, a state can go ahead and prosecute even a president of the United States and the president has no control over it. So that then gives rise, Larry, to your question, which is in that circumstance, and it's really in that circumstance only, because if it's a federal conviction, Trump can get rid of it, but a state conviction, he can't. So can a state jail the president? Because the president has no ability to undo that conviction. That's a hard question. And it should be a hard question because what you don't want to have is have one state have the power to undo the national will. I mean, obviously here, I think many people, you know, have their doubts about Donald Trump's ability to run this country or, you know, run even Mar-a-Lago. But nonetheless, if those two the people voted for, I think it's a pretty grave thing for one state to try and interfere with that. And so it's going to be a difficult, tough constitutional question. I mean, just think if it's like 1862 and South Carolina tried to jail Abraham Lincoln, how would we feel? And of course, Trump is as far away from Abraham Lincoln as one could possibly be. But when you're thinking about constitutional law, good constitutional law, you have to do it without reference to who the parties are. And you have to know that whatever precedent you set here is going to apply down the road.
Well, and you know, as we know, our legal system can work very slowly, even if the former president is convicted in one or more of these cases. Couldn't the appeals process drag out for years? Absolutely.
Absolutely, it could. And so, but, you know, and he will be free on appeal. Yeah.
And how do the locations of the trials factor into this? Because you've got South Florida, you've got New York City, you've got Fulton County, Atlanta. Are all of these unfavorable environments to the former president, or maybe he has a better chance in Miami?
I mean, Earth is an unfavorable environment for Donald Trump. I mean, you know, I think these trials can take place anywhere and he will lose them because trials, unlike his Truth Social media environment, are guided by ordinary principles of law, regular rules of evidence, you know, decorum and the like. And all of that is anathema to Donald Trump. So, you know, yes, are there people who say, oh, this trial will take place in DC and that's better than Atlanta or Miami or whatever? Sure. I think the prosecutors in all these cases are absolutely confident in their cases, as they should be, because, you know, they're not difficult. I mean, particularly Mar-a-Lago. January 6th, you've got some complicated questions about, is the president engaged in speech and so on. I don't think they're actually that complicated, but at least they, you know, you can imagine an oral argument over that. But at the end of the day, I think Trump is in really, really dangerous hot water with all of these cases.
I'm going to ask some questions from our viewing audience. If you have questions, please feel free to put them in the Q&A there on your screen, and we'll do our best to get as many of the questions in as we can this evening for Neal Katyal. Cherie asks, how many gag orders can the former president violate before he goes to prison?
I mean, you know, the range is infinite. He is incapable of following just the most basic rules of decorum that anyone else would apply to anyone else. And so, you know, like, you don't need to be a rocket scientist to know if a judge says, hey, don't intimidate witnesses, you don't intimidate witnesses, or don't intimidate court staff. So he was fined $5,000 last week, fined $10,000 yesterday. I suspect there'll be one more monetary fine. And then we are talking about former president of the United States, current criminal defendant, Donald Trump, being put in jail before his trial's even over. And
You think a judge would actually do that while the former president is campaigning for president?
I think they have to. I don't think there's a choice, because the entire legal system depends on respect for the court. And if you allow this high-profile litigant to do what he's doing and to continue to do it after he's been warned, how do you do it? How do you say something different to anyone else? There's no like rule that says you're running for president, you get a special rule book. There is a set of rules, you know, that say if you're the president, a sitting president, you cannot be criminally indicted. That's something that the Justice Department wrote in 1973 and again in 2000. I disagree with that, but that is the way they've come to it. They've come to that conclusion. But, you know, that's true for sitting presidents. And what, you know, Donald Trump, I know, thinks he's still the sitting president, I guess, but he's not.
As you know, I'm sure UC Berkeley, Dean of the Law School, Erwin Chemerinsky, the ACLU, they've both come out being critical of gag orders. I believe it's in the federal case, if I'm not mistaken, where they're critical of it and say that it does run afoul, in their view, of free speech. What do you think?
Well, I mean, the ACLU is going to do what the ACLU does in every case, which is stand up for free speech, and my hat's off to them for making that defense. But I think it's a loser defense. I mean, here I think you have a very narrowly targeted order that says to Trump, there are certain things you can't do. There's lots you can do. You can attack the prosecution as politically motivated and the like, but you can't intimidate the court witnesses, the witnesses and the court, and, you know, people like that. And so that seems eminently reasonable. I think if this were to go to the Supreme Court, which I don't think it will, but if it did, it would be upheld 9-0 or pretty close to it.
We have Janice who says, and this is really more a political than legal question, but if Trump is found guilty before the election, what effect do you think it could have on his support?
I think it will be significant. This is something that goes all the way back to Tocqueville. The Americans do respect juries. I saw this really firsthand when I was privileged to serve as special prosecutor in the George Floyd murder in Minnesota, and I worked for the state. And when I first started, right after the May 25th, 2020 murder, you know, the city was incredibly tense. It was a very scary time. And the world in Minnesota was very divided about who was right and who was wrong and so on. When the jury rendered its verdict, to say it was very well understood by everyone. There were very few protests, very few dissenting voices, because Americans trust the jury system. And when you get 12 people who are not connected to the case, and they look at it and they say, beyond a reasonable doubt, this is what happened, which is the most difficult thing for a prosecutor to have. It's the highest standard in our law. It's not like 51% guilty. It's a really gotta be guilty. And to win a prosecution in the American system, all 12 jurors have to agree that the guy did it. If you have one person who says, I disagree, you can't convict him. So when you have that, all 12 impartial, making such a decision, I think it's the end of his campaign. I mean, sure, will there be people who naysayers who, continue to believe him, who've drank the Kool-Aid? Sure, but he's not presidential material.
Christine says the penalties for Sidney Powell and for Jenna Ellis seem to be more like slap on the wrist, given the gravity of the allegations. Might that signify that Fani Willis's prosecution case wasn't as strong against them? And does that have anything to say about the potential strength or weakness of the case against Trump?
So we will have to see, but there's two explanations for a lower sentence. One is they're getting rewarded for coming in and cooperating. The other is, well, they didn't have very much against those people. I strongly suspect it's the first. There's no reason why you'd be trying to build this massive RICO case and the like, unless you basically had the goods on the smaller people. They've now turning and providing evidence against the higher ups. Jenna Ellis, for example, even if she's going to claim she wasn't in the room with Trump on a lot of stuff, she clearly was with Rudy Giuliani. So one of the strategies prosecutors are doing is go after Ellis. Ellis will give you Giuliani. Now go after Giuliani. Will Giuliani give you Donald Trump? So, look, we already know so much from the January 6th committee. It's not like Fani Willis or Jack Smith needs Giuliani's testimony. It's gravy. It'd be nice gravy to have, but that's what it is. And, that's why ultimately, at the end of the day, I know there's criticism of Willis, there's criticism of Jack Smith, who, by the way, is an independent, non-political prosecutor, but they're claiming, oh, they're doing this to undermine Trump in the election. And I just, find that so bogus. The reason to do this is not because it hurts Donald Trump in the campaign. The reason to do this is someone who acted in our highest office this way, in the most anti-democratic of ways imaginable, that person belongs in jail. That's the proper place for someone like that. And regardless of the political consequences, indeed, Trump often says, oh, these indictments help me politically. So I don't really understand how on one side he says they help him, and then on the other he says it hurts him. But regardless, I think as a prosecutor, anyone who served at the Justice Department knows the thing you do at the Justice Department is you make cases based on the law and not on anything else.
Linda says, you keep referring to electors as fake or illegal, but throughout American history, many states have sent alternate electors to DC for presidential elections. So what makes an elector fake?
Yeah, so Linda, I don't think that that's happened with another set of electors that are replacing the duly enacted ones that were chosen by the people. So there's two sets of problems with it. One, you'd have to show serious fraud and wrongdoing in order to even trigger the possibility of an alternate slate, which 62 different courts looked into. All 62 courts concluded there was nothing to it. So that's one serious problem. And then the other is, even if you do think there was fraud, does that give you the remedy of a state legislature throwing out the popular vote and imposing your own slate of electors? That's the issue that I just argued in the United States Supreme Court in a case called Moore versus Harper. And the Supreme Court, which is a very conservative court, but threw that argument out 6-2 and said, no, in this country, state legislatures don't have that kind of ridiculous, untrammeled power. Because if it did, like, I would ask Linda, do you even know the name of your state legislator? You probably don't. Most Americans don't. And the idea that that person gets to pick the next president is ridiculous. I mean, maybe that's the system in, Soviet Russia, but it's not the system in the United States.
This you answered part way, but the question is if the former president was elected president again, could he pardon himself? You said from the federal conviction, yes, he could, not from the state. Is it clear that a president can pardon himself? Because I thought that was a contested issue.
I didn't say that a president.
Oh,
could pardon.
okay. Then I misheard
So
you.
I don't think you even get to that question, because if Trump won in 24, he would order the Justice Department to drop the prosecution. And as president, the president is undoubtedly in control of the executive branch. He's the head of it. That's Article 2 of the Constitution. And the Attorney General and Justice Department are part of the executive branch. So he is the big cheese, I guess it's the wrong word to use with Chesbrough, but he's the guy who controls the executive branch. And as a result, he can order any federal prosecution dropped. He can get impeached for it. It's not like it's a total win for him, but he does have that power under our Constitution.
But if he's convicted, what would it matter if the case is dropped at that point?
Because he's presumably appealing. And so if he's appealing, then the Justice Department has formal control over the case, and they can essentially confess error and say to the Court of Appeals, we are dropping this prosecution. And there may be some court review over that, but at the end of the day, I suspect that the president has the authority to order a prosecution against himself, even a conviction, dropped. So now there is a question, can the president pardon himself? So let's say the appeals process were all over and the Supreme Court agreed that he committed the crime. Now what can he do? And then you get into the question that you're raising, Larry, based on one of our listeners, which is, can the president pardon himself? And the best article on that was written by a professor named Brian Kalt, K-A-L-T, in the Yale Law Journal. And I kid you not, the article is called Pardon Me. And the argument in Pardon Me, which I think is right, is that presidents can't pardon themselves because foundational to the Anglo-American legal system, going back all the way to Dr. Bonham's case, which I think is in 1605, is the idea that a person can't be a judge in their own case. And that would make the president the judge in his own case. But
Right.
As you were saying, Larry, it's a contested issue, and you can imagine both ways. Now, state prosecution, no power, no federal pardon power whatsoever.
I wanted to ask you about some other legal issues, and we're getting short on time. So I did want to ask you about the ruling, which was not unexpected by the federal court, about Georgia's Republican redrawn districts, which advantaged Republicans. The decision that violates the Voting Rights Act. My understanding from one of these programs I did just a few weeks ago is that they're already standing by to redraw those districts. But what's your thought about where we stand on federal courts and ultimately the Supreme Court's willingness to step in and tell states they've got to redraw districts that are protested as being gerrymandered and unfair?
Yeah, I mean, gerrymandering is a real sin against our democracy. And it's going on by both political parties. It's not like only one is doing it. But what it means is that, every 10 years, there has to be a census, and the maps for federal congressional elections are drawn by state legislatures. And so particularly the Republican Party has made an effort to try and enact and win state legislative elections so they can draw these maps in ways that are really favorable to them. So like in North Carolina, which is my Moore versus Harper case that I mentioned before at the Supreme Court, the state legislature drew the maps so that there were 11 Republican districts and 3 Democratic ones in the entire state, even though North Carolina is a politically evenly divided state. It's roughly 50-50. So instead of a 7-7 split, they had an 11-3 split. And the US Supreme Court, unfortunately, in a case called Rucho a few years ago, said, we federal courts, hands off when it comes to gerrymandering. We're not going to touch this. they said state courts can play a role. And indeed, that's what happened in Moore versus Harper. The North Carolina Supreme Court said, hey, this is unfair. You can't draw districts in such a disproportionate way. So we will see some relief at the state court level. But at the federal level, the US Supreme Court has said, we're out of this business. They've never been in it, but we're not touching this.
And we in California, we have a Citizens Redistricting Commission. Is the trend toward there being more of those across the country?
I would love to see nonpartisan redistricting take off, because the thing is, with the advent of modern computing power, these legislatures can draw districts in such jagged, funny ways, they can disempower people massively, and your vote just doesn't count. And that wasn't true 50, 100 years ago in quite the same way as it is now. The problem is, like, if you're California, you're one of a few large Democratic states, do you unilaterally disarm when North Carolina is doing the opposite? And so, it's hard for certain states, for any states, to say, we're going to get rid of gerrymandering when you know that your opponents are doing it in the next state over.
I wanted to ask you about the High Court. You argue so many cases and have throughout your legal career in front of the justices. And I know you have to be cautious about comments you make because you'll be going back before them. But I am interested in your thoughts just about the ideological composition of the court, because we're really seeing, it seems, Justice John Roberts, the Chief Justice, and Brett Kavanaugh as becoming swing justices in a number of cases. Of course, on the right, you've got Alito, Gorsuch, Thomas, and Barrett. You've got on the left Kagan, Sotomayor, and Jackson. You surprised at all sort of by how this alignment has occurred with those two justices being swings?
Yeah, I mean, I would say that the court is, first of all, I was born in 1970. The court has always had, in my entire lifetime, every day I've been alive, the court has had a majority of Republican appointees. That is, 5 or more of the 9 justices were appointed by Republican presidents every day for the last 50 plus years. But I would say that these 9, on average, tend to be more conservative, in some cases quite a bit more conservative than their predecessors. And so to take a look at a case like Dobbs, for example, the abortion case, I think that was unthinkable for earlier Republican appointees. Indeed, when Roe versus Wade was in some jeopardy, people thought back in 1992, in a case called Planned Parenthood versus Casey, it was a trio of Republican appointed Justices O'Connor, Sotomayor, and Kennedy, O'Connor, Souter, and Kennedy, that came together and said that Roe was the law of the land, that social expectations had crystallized around it, and that it was a super precedent that couldn't be jettisoned. And what happened just a year and a half ago? They threw it out, jettisoned it. If you can do that to Roe, you can do that to any case, because Roe was the hardest case for these justices to overrule, and yet they did it. And so I think your questioner is right to say, is this court look different than other courts? Why is this night different than all other nights? This is different.
Since the Dobbs decision overturning Roe v. Wade, the court is now being asked to rule on whether the FDA properly approved the abortion medication mifepristone more than 20 years ago. And one of the big questions, the center of that, is telehealth. We're really getting tight on time, but this is a big deal because of so many states that have enacted abortion restrictions. Since the Dobbs decision, telehealth would allow women to be able to get prescriptions for the drugs in those states where it's hard to get an abortion. You think it likely the High Court will take that up?
So just a disclosure, the mifepristone case is my team's case. And so, take what I say with a grain of salt, but I think the claims that are made by those who are trying to get rid of mifepristone, a drug the FDA approved in 2000, are, ludicrous. And I think, I'm optimistic that the United States Supreme Court will see it our way. The idea that you could allow any random doctor anywhere to say, this drug that the FDA approved is giving one of my patients headaches and side effects, and therefore I can sue to take the drug off the shelves. That's crazy. Every drug has side effects. And we don't allow the federal courts to second guess the FDA's expertise and judgment. And it's also, I think, fairly clear that the motivations behind this lawsuit are not the headaches that people suffer from mifepristone. It's something quite different.
I thought it also, and you're the expert, of course, but I thought part of it was the claim that there had been subsequent approvals by the FDA allowing for telehealth and other things. And the contention was that they violated their own rules in doing that approval without more testing or whatever. Is that not an issue?
So in 2000, there's an initial approval, and then 2016 is an expanded approval, including telehealth and things like that. Of course, the challengers are trying to get rid of both the 2000 and the 2016 approvals. I've only spoken about the 2000 one. You're right, but you're absolutely, but the 2016 is no better ground for them on which to stand. Obviously, they complied with the rules and so on. This isn't about compliance with the rules. It's about something else.
Professor Katyal, I just want to give you an opportunity for a quick closing. We've spent most of our time talking about the legal travails of former President Trump, but I'd like you to just share your thoughts about the future of American democracy, given what you've seen with these prosecutions, concerns about efforts to try and control elections. And are we turning a corner? Do you have any positive thoughts about where we're going or not?
I do, even at this dark moment, I do. You could look at events around the world, and you could look at the way in which the Republican Party picked their speaker and think this is such a horrible time. And it is. I don't mean to diminish any of that. But I do think there are also signs of optimism, whether it's the prosecutions we've been talking about and the rule of law coming back, or the speeches that President Biden gave in Israel, which I thought personally spoke to my heart and to the needs for a humanitarian approach to this, and an approach that recognizes the grave history of oppression that the Jewish people have faced. I look at, even a Supreme Court that's quite conservative, but doing the right thing in a case like Moore versus Harper. And I look at a lot of energy among young people. And I just got to meet California's newest senator last night, and I was very taken by her as well. I mean, these are people who politically, she doesn't, for example, represent my politics, but these are good people who are coming in to serve and to try and make the country better. I didn't feel that way about the last administration, and I don't mean that politically. I mean that just in a sense of judgment, wisdom, respect for American traditions, respect for our place in the world. All of that, I think they spit on. But I do see a new generation of leaders coming in, and hopefully with all of you, remaining vigilant and pushing and getting out there, I'm optimistic. So,
Professor, thank you so much for joining us tonight. We really appreciate it. And congratulations on, can you share what awards you're getting tonight?
The National Law Journal Award, which I'm getting in 3 minutes.
All right, congratulations. Thank you for
Bye.
stepping out to join us this evening. I'm just going to close with just a couple of thoughts about David Lair. These programs are a fitting testament to David. The work he and Janice put into these programs with the support of Zev and Mel is just tremendous. And with Community Advocates, Inc., David devoted his professional life to cultivating honest conversations about our greatest challenges. And these programs are such an example of that. If you'd like to give a contribution, tax-deductible contribution to support these programs and in honor of David, you can do that on the website for Community Advocates, Inc. That's Community Advocates, Inc. You can also make a contribution on the website for Jews United for Democracy and Justice. Either place is fine. You know, David was a sounding board for me who helped me deal with frustrations or uncertainty on how to handle a particular topic. He was such a presence. It's very hard for me to accept that he's passed. His life force was strong, and the need for his work is so great. He leaves a tremendous legacy in these programs, which I'm sure will continue under the leadership of Jews United for Democracy and Justice. David Lair has given our region so much intellectual integrity and moral clarity that we've really needed. And I certainly hope that that will be part of his legacy going forward, are the things that he shared with us and that he represented in his life's work. Next week, a terrific program. Warren Only, my friend, is going to be moderating that with the New York Times Pulitzer Prize winning editor of the morning newsletter, David Leonhardt. That's back here on the usual Wednesday night. Back to Wednesday night next week, 5 o'clock Pacific time, Warren Only, talking with Pulitzer winner David Leonhardt of the New York Times. From all of us at America to Crossroads, and in tribute to David Lair, co-founder of this series, thank you and have a good evening.